couple of things before we start, just to point out. So the only thing that I have anxiety about, as I wrote last night, is getting the student groups straight. So hopefully my email from last night was clear, and after class today we can go through that. The video upload site is working. If you go to the blog, top right-hand corner, you will see that there is a button. And the one thing it doesn't do is it doesn't allow you to upload directly from your mobile device. So you're going to have to go mobile to computer and computer up. They're working on that solution. The other thing, two other kind of small announcements while they figure out the network issue. With respect to the syllabus, I have added a couple of things. On the positive side, I have added bios for as many of the speakers as I could find online. And since many of the people from California and elsewhere are promising to actually fly up here, you might be interested in who they are, because they're a pretty cool group. I have also added, this you will be less happy about, materials for the last class. But they are not really materials for the last class. They are two things that I couldn't recommend more highly, and watch them or listen to them at your leisure over the course. They are rather long, but they are both fantastic. Bruce Springsteen's SXSW 2012 keynote. If any of you are musicians, you've got to listen to this. He goes through the creative process and really explains beg, borrowing, and stealing. You know, even if you're a Springsteen fan like I have been ever since I had mono in third-year law school and listened to Darkness on the Edge of Town, the album, about 3,000 times in the 4 weeks that I was in bed, it was astounding. I didn't expect him to be that good. The second is Jonathan Zittrain's keynote at ROFLCon on memes and society, and it will just make you laugh and laugh and laugh. Jonathan is a professor of law at Harvard and at Berkman School, but those two really belong under the ethics section. That's why I put them there. But if you have a spare moment, and the Springsteen talk, I guess for copyright reasons, ironically, is only available on audio, so you can have it going in the background. There used to be a video version, and it's just not there. If anyone can find it, great.
Sorry to interrupt.
No problem. The network is down. Okay. Maybe you can just email Richard and let him know. So if anybody wants to get video of this going, awesome. Oh.
Maybe a little.
Now, any questions? Okay. Ready to go?
How you doing?
How are you?
Good, thanks.
I try and hide these. I don't want to embarrass myself. Okay, today there is an objective to this class and to this talk. Really two objectives. The first objective is to trigger, for the benefit of your papers, some notion of what you want your perspective to be. Not your subject. Your subject will come as we canvass the various subjects relevant to video games and digital media law. But what's your perspective? And your perspective need not be mine. It need not be Rock's. It need be your own. But my objective today is to get you thinking about what it might be, because that's actually more important than the subject. Rock, in the second hour, is going to be taking you through a magical mystery tour of cases. So I'm going to be taking you through only a few concepts. Before I do, I want to follow up on the first talk. I raised whether games have an evolutionary purpose. How do we answer? There must be an answer here. Oh. That must be Richard calling. Sorry, we will edit this out later. I should probably hit that, if that happens again. So I raised in the context of my cousin's book the notion that games and video games couldn't be, and entertainment couldn't be entirely meaningless. They must serve some evolutionary purpose. Interestingly enough, my colleague, Dr. Kimberly Vull, ex-UBC computer science professor, is giving a game design course at the Center for Digital Media, which I'm auditing on Thursday nights. And her first talk was about why games are important. And 2 points that were relevant as follow-ups, the notion of Hebbian learning, neurons that fire together, wire together. So that would have an evolutionary purpose. And this is a quote from Kim: "Fun seems to be something our brains use to keep us doing something to the point of mastery. Makes sense if it helps us live better and improves the gene pool." So, now what did I do? My remote. That's the sadly less serious. Oh no. How do I go backwards? This is not going well. There we go. That sadly is the less serious follow-up. You may have followed, and you may have followed on the course blog, the suicide of Aaron Swartz. If you haven't, go to the blog, check out some of the articles. We talked about, in the first talk, the road to legitimacy for video games. And what occurred to me was be careful what you wish for. We talked about Atari and Oman, and the many challenges that came with the consequences of legitimacy under copyright law. So you want to be taken seriously, and sometimes being taken too seriously has its consequences. Likewise, Aaron Swartz was in no way trying to benefit himself. He was standing up for free access to information, and he was prosecuted for that. Some would argue persecuted for that. And be careful what you wish for. Now there's a quote that it would be useful if it resonated throughout the rest of this talk for you. It's from the prosecutor in the Swartz case, obviously long before the suicide, in a press release, I believe, around the case. Stealing is stealing, whether you use a computer command or a crowbar, and whether you take documents, data, or dollars. It is equally harmful to the victim, whether you sell what you have stolen or give it away. So point number one, in terms of perspective for your papers, really? Really legally? Really otherwise? Do you agree with that? Do you not agree with that? This is a copyright literalist, an intellectual property literalist position. More on that later. One additional postscript. Brilliant paper if anyone wants to do it. Would the Swartz case have been seen the same way in Canada, given the Supreme Court of Canada pentology, and given the specific provisions of our criminal code? It could be suggested, because there are criticisms of the Supreme Court of Canada, the 5 cases that came out in August that establish users' rights, that they went too far, too fast, and that they overreached in terms of what they had to do. They weren't as narrowly defined as they could have been given the facts in the case. Well, had the US Supreme Court gone where they're likely to go, perhaps the atmosphere around prosecutions of hacktivists might be a little bit different. It's a question, not an answer, not a statement.
Let's chime in. I read the Ninth Circuit in the US had decided a case similar to what was being prosecuted against Swartz, and they had dismissed the case.
It's a very weak case.
So it didn't have an influence, unfortunately, in this case.
Nope, and there are allegations, I don't know if they're correct or not, that the prosecutor had certain kinds of political ambitions, et cetera, et cetera. So all of that plays out in time.
Apparently the U.S. Department of Justice actually dismissed the charges recently, like after Swartz committed suicide. So they've actually said, we're not going to do anything about it, although it's clearly too late for that.
Is that something that's done matter of course, do you know?
What's that?
I mean, a criminal case against a dead person, it's not like you're collecting damages from their estate. I think it's matter of course. I don't think it's...
I hate to raise this in the wrong context, and I'm not an American lawyer, but habeas corpus. I mean, who are you prosecuting? So I can see it in a civil context. In any event, back to our regularly scheduled programming. So last week I left off with saying, I'm going to try and surprise you this week and explain why expression and speech are not paramount, and why the real censors that come into play around video gaming law are not the concepts we might expect, and other concepts, in fact, rule. I'm going to start in a very conventional place, but a really important one to you as law students. I've been practicing in and around freedom of expression and freedom of speech law for 30 years, and I have yet to find better arguments, or in fact any argument, that is not contained in John Milton's Areopagitica, written in 1644. if you're interested in the area, it is a must-read. And it just sets up the basic parameters of why information should be free. The situation was this was a speech to Parliament by Milton arguing against the licensing of printing presses. Printing presses should not be licensed. Parliament did license them. They didn't listen to Milton. Milton has been vindicated. I'm not going to quote the charter to you, but you know the words. I want to just briefly focus on the words in section 2A and B for a slightly different purpose. Conscious thought, belief, opinion, expression, press, media, and communication. Those are the magic words. In the US, freedom of speech, also the word press appears. Why do I raise those words? I'll tell you in a second. The cases that you have in your readings are the usual suspects. Situations where the state wants to narrow the right of access to video games, deal with video game parlors, great concern about the moral degeneration that flows from gaming. And as you will see, the principles go back in the States and in Canada a long way. And generally speaking, freedom of speech and freedom of expression triumph. This is the usual scenario, the usual setup. I want to go back. When you look at the incantations in our charter and those magic words, conscience, thought, belief, opinion, and expression, freedom of the press, freedom of media, do you see anything missing? Is there any word, is there any concept that might fall between those cracks?
Well, one of the things that seems to come up in some of the video game cases on this is they keep emphasizing the interactive element. So it's almost like the thought, belief, opinion, press, media, that's almost seems to be an individual piece as opposed to actually interacting. I mean, there might be some sort of freedom of association in there, but it's not really association per se.
It's not association per se, but you're very close, because what you're getting at is that what interactive media, including games, does is democratize the expression. And in democratizing it, because everyone has access to it, there's a certain two-way reality. Is there another word, though? Does anybody see a word missing? A category missing?
Seems to not have anything about action. Like
Oh, you're really close.
activity. Like you can think about it. You can
Creation. Is create a missing word, or is it subsumed under expression? Hold the thought. Is creation the same as conscience? Is it the same as thought? Is it the same as belief? Is it the same as opinion? Is it the same as expression? That's the closest, for sure. Is it the same as speech in the American idiom? Is it the same as the press? Is creation a media of communication? Not a perfect fit, perhaps. I will eventually learn how to use the clicker. Okay, now the as advertised programming. We're talking about constraints on digital creativity. We're talking about constraints on games. So what do we measure freedom of expression and freedom of speech against? What are the constraints that freedom of speech and expression countervail? So there are 6 of them. 5 of them we are going to explore, generally speaking, in other parts of this course. But I want to list them and introduce them and tease them. The most obvious is the current state of intellectual property law. You've already heard a lot. You're going to hear so much more until you're virtually ill on the subject. What are user rights? What is a right of creation? Is it part of copyright? Is it a separate right? Obviously, IP law is a constraint. It is also, some argue, an enabler of creativity. It's a two-edged sword, to be sure. Tort law. So we have cases both in the book, and you can easily find them, involving Columbine, involving parents suing entertainment companies, including video game companies, saying something terrible happened to my child, and you are vicariously liable for it. We have privacy. Consumer protection, in part, mostly coming through contract, which means mostly we're giving away our privacy when we tap the I agree icon. More on that later, but certainly a constraint. Contract law, that's really the big one. End user license agreement, terms of service, whole next part of the course. We'll focus on that. And that creates a lot of constraints on certainly gamers' rights, but also developers' rights. Because let's remember that this contractual regime, though it may originate in intellectual property, gets parsed out through contracts, and creators of video games and developers are subject to license agreements and contracts with up the line all the way to wherever the original IP is. So it wields a huge power and casts a huge shadow on the landscape. And then, related very much to the cases, societal protection laws, criminal laws, and the various regulatory regimes that are delegated thereunder. Now the final one. That was the simple typology. The advanced typology is how do you measure freedom of speech and expression against itself? And that's the question I asked earlier. here I go back to kind of what I think is a seminal document, the Universal Declaration of Human Rights, Articles 18 and 19, freedom of thought, opinion, expression. It all becomes a bit of a circle when you say, where is the right to create in this? Questions, comments, pushback, feedback.
Well, I guess I think you kind of just said this, but maybe in different words, that if you have a right to create, I mean, I think the reason you're using the word itself there, maybe I'm wrong, but is that the second person's right is battling against the first person's right, the original creator, potentially. So, you know, if we give people this right to remix or to mod, then just the way other rights are kind of bound by what we, you know, you can say whatever you want as long as it doesn't harm anybody. Well, you can create whatever you want as long as somebody else didn't already create it, and you're taking it from them.
Zohar, when you talk about the battle, you really are focusing on, quite appropriately, the literal aspects. And that's where the problem, as you've hinted, really lies. It is whenever you say, this is mine and that is yours, but in the context raised earlier, well, we're doing this together. I'm creating, you're creating, we're in one virtual space. It loses meaning. So how we overcome that and what kind of structure or ideas might allow us to go there is very much a core theme of the course. There's a whole body of law, and having taken constitutional law and perhaps advanced constitutional law, you'd be well ahead of me on this. But there's a question of what do you do with unenumerated rights. It's very much a live issue in the American constitutional structure because, of course, their constitution goes back a long, long way, a lot further back than our charter. And the language, therefore, is not as encompassing, not as specific. And there are various schools of thought. One that the Justice Scalia and others, that you have to interpret the US Constitution based on what the founding fathers of the United States were thinking at that time. The opposing view, I would say, is Justice Posner, not on the Supreme Court, but who's written a number of books on the subject, suggesting that there's a great deal of malleability and constitutions need to change with the times. And then kind of a middle position that says we can't be bound by the literal words. There are unenumerated rights that exist in a constitutional context, and they lie within the continuum, but they can't be just invented. And in a Canadian constitutional context, we're going to see 100 years from now debates like this come up inevitably, because there will be needs for new rights. We evolve, our structures evolve, our societies evolve. Nobody could have foreseen digital creativity 100 years ago, and the notion of a right to create would have been quite non-obvious. Whatever it's worth.
Can I just ask one thing? You know, because you were just talking about years ago or so. I was just thinking about if you had a piece of literature that was written and it was, let's say, half a page long, and then a person came and decided to erase the period at the end of the last line and then just keep writing. Is that not something analogous to what we're talking about now?
Analogous in a very specific, very limited, geographically, physically sense. With digitization, it's a matter of scale. That is so incredibly scalable. But in terms of the meaning of authorship specifically, I don't mean to tease, but next week is going to be about how, whether the author is the final step in the chain, or there is a creator within the author that is now unleashed in the digital world that is one more step. And I know that may sound obscure, but hopefully we'll get you there. Now, this gets you a little closer, and then I'll come right to you, Ken. The obscenity cases. And this is just one of my favorite books of all time, Edward de Grazia's Girls Lean Back Everywhere, The Law of Obscenity and the Assault on Genius. The obscenity cases in all contexts, certainly in North America, but probably in all legal regimes, go to this a little bit, because you have to. If it's simply words, it's not enough. And the importance of creative intent does manifest itself in those cases. So if you, for the purposes of your paper, are looking for a legal metaphor, that's where you're likely to find it. This is a picture from Microsoft Flight Simulator. And we've done our flyover, and it's not surprising if the terrain starts looking a bit obscure to you. Hopefully, by the end, we'll get you to a little more clarity and towards the horizon. So, how do we deal with creativity? And are there responsibilities that go with it? Core, what is an idea? When is it expressed? And in legal terms, expression goes to fixation. What rights attach to the expression? What responsibilities attach to the expression? Is ownership a bug or a feature? Sorry for the tech talk. Many would argue, certainly all the big IP lawyers and the big firms in Toronto would argue, that ownership property rights in IP are a feature and they unleash creativity. And Aaron Swartz, rest in peace, would argue the opposite, that intellectual property restrictions curb creativity. Let me, my friend Ken's been waiting for a while.
I'm struck by the notion here. Again, you began almost with this distinction, Scalia's notion of the founding fathers. But even amongst the founding fathers, we go back to John Locke. What you're talking about is a discussion of property. And we're talking about a specific type of property, an agrarian property. And in the agrarian property, whoever owns the property has exclusive use of that property. They can license it out, they can rent it, but whoever gets to claim it first is the owner against all other comers. And much of our traditional property law, which is one of the reasons why intellectual property may well be a misnomer, has been to give that sort of exclusive right to an individual who has been able to associate themselves with a particular expression or idea. The problem is that when we start to look at collective ownership, or we look at a different model of ownership, we may in fact be looking at non-rivalrous ownership of property. Where non-rivalrous ownership of property says, if I take John's wallet, John can't use his wallet, because I have it. But if, in fact, I have something that if I take John's reputation as a video game scholar and I attach my reputation as a legal scholar to it, and between the two of us we produce something, even if it's not in concert, which adds to the overall knowledge, which adds to the overall understanding of video gaming, we have created something greater than the whole. This is referred to in economic theory as network externalities. And what it says is that by taking from John his initial copyrighted written ideas about video gaming, and by adding other things to it, by taking it to a larger audience, I can now make it so that he finds it easier to get an even larger edition for the second part of his book, because now there's more interest. There's a bigger market. That network externality then is something which adds to, and rather than depriving John of his of return for his original kind of creation, what I may have done by interacting with the sorts of things he's talking about is to increase the overall value. That sort of approach, that non-rivalrous approach, has a great deal of appeal for user right type of people.
So that was a wonderful and perfect comment. I'm only going to push back on one thing, which some of you will know. We could, with the use of a MakerBot, replicate my wallet. Mm-hmm. And we are moving to that world with MakerBots, where we are able to physically replicate things and take that scarcity away, even in the physical world. And there was on our blog this week, thanks to Tyler, a wonderful starting point around what's the next world of gaming going to look like. And the discussion really tended towards it's going to have a lot of physical aspects to it. And what we're really doing is we're taking the scarcity of what happens legally when we take the scarcity out of the physical world.
But one of the things that's sort of still involved in that is that the old notion of exclusive ownership has been the base of many of the models of how you can monetize, how you can get some sort of recompense for your investment in whatever it is that you create. That has been the traditional model. I control the assets. I may only be able to get that control for a limited period of time, but it is in that limited period of time that I will in fact be repaid for all of my investment of time and thinking in the creation. That's a little different though, and it is something that was anticipated even in the time of the founders, because John Locke is talking about the collective commons. For an agrarian society, you could have collective commons where everybody could bring their animals to graze in the commons of the village. Trouble was, is the guy who got there with the most number of animals first, his animals could often graze everything flat, and then there'd be nothing left for the other people who were a little bit slower getting there. That's called the tragedy of the commons. So when you look at John Locke's discussion about the mixing of one's labor with nature's bounty, with natural resources, he comes up with something that's called the proviso. It's called Locke's proviso. The notion is that I am entitled to claim as my own, for exclusive use, anything I have mixed my labor with, so long as I leave as much and as good for anyone else. What the network externality does is it means that we're pouring more resources back in to the commons. We're making it so it's almost as though I've taken my flock in there first, but I'm also fertilizing the grass and I'm making sure there's a lot more for everybody else that's there. And it is that kind of new exciting notion of an economic model that has to be, I think, anticipated. But it was anticipated even a couple hundred years ago, long before the digital era arrived.
So perspectives on the meaning of property, or the meanings of property, are very much part of next week's class. So we will be here again. There was another question.
I'm actually just curious, the patent thicket problem that you have in things like mobile phone technology, where companies or non-practicing entities are amassing more and more patents in a certain area. Does this happen in video game law? Do you have video game companies that are?
Yes.
Okay.
So the current, I'll post it. We're not going to have time for news of the week so in this class, so I'll post my favorite 10 stories, and I'll add this somewhere else on the blog. But the current one, you'll see in the possible invited speakers for the course. Where is... I was thinking if we might want to get the person who started a game called X-Plane. His name is Austin Meyer. He's from Texas. He created a game that effectively has displaced Microsoft Flight Simulator as the hardcore flight sim. And he did that by creating a physics model that is amazing. I will leave you with that. He is being sued and in the midst of a huge lawsuit and going to the community. Please look it up online. X-Plane lawsuit. Austin Meyer, you can feel free to Google it right now. And he is feeling highly oppressed, and it would appear, certainly from his various outpourings, that it's a troll. And he's part of a troll lawsuit, and he talks about it in detail, and his posts are very interesting. And they don't go at all to the core technology of what he really came up with, which was a physics model. So it's well worth, and he has posted the lawsuit online. So to go directly to your question, it's there. That's the latest example. Just want to introduce one concept before we move on, and that is the current conceptual framework when you're looking at creativity and responsibility. The simplest iteration is Section 230 of the Communications Decency Act in the US, which basically creates a right of republication for ISPs and for providers. So you get this interesting bifurcation. If you are just a provider, a network provider, just a means of distribution, the paperboy, the digital paperboy, you are not responsible for the content of the paper. You're not responsible for the defamation. You're not responsible for the copyright breach. But if you are the author, the writer in the newspaper, the publisher of the newspaper, digital or otherwise, you have responsibility for that content. But you also have freedom of expression under Section 2B and the First Amendment in the United States, so you have a bunch of protections. So I call that the current conceptual framework because so much of this course, as you've raised, is what happens when we mix all this stuff together. The traditional frameworks start falling apart on us. So you'll see citation to a very interesting paper called First Amendment Protection for Search Engine Search Results, commissioned by Google. Eugene Volokh is at UCLA Law School, and in the index, Proposition C, please go to the paper, it's really worth it. That search engine results are created with the help, that search engine results created with the help of computerized algorithms do not rob them of First Amendment protection. So now the argument is there's no human author here. There's no traditional paradigm of an author. Does it still attract freedom of expression, freedom of speech protection? So we're getting into, depending on your metaphor, your preferred metaphor, deep waters, high mountains. Now, apply this to World of Warcraft. Apply this in any massively multiplayer scenario. In any game, you see the mixtures of algorithms, real players, infinite worlds, human interaction, computer interaction, preset branching situations, arbitrary events. What standard applies? I'm hoping that you'll tell me in your papers. Okay. So we're talking about freedom. We're talking about freedom from constraints. I do want to allude to a couple of conundrums. The first has to do with privacy in IP. The second, sort of IP within itself. And I hope these will clarify or start bringing some clarity to this discussion. So those of you who, it's not so much in video game law, but in digital media generally, if you have political inclinations or were a poli-sci major or just generally interested, you might notice some patterns evolve in terms of positioning. And sort of odd patterns. Maybe they're not odd, but through the lens which I promised you, the ethical lens of the double standard as a test, they seem odd. So we have the IP literalists. Intellectual property taken literally. It's property, they argue, and as the prosecutor who I quoted earlier said, it doesn't matter whether you've stolen a bit or you've stolen from a bank. It's all the same in that quote. Physical objects from a bank, digital bits that are encrypted. What's the difference is the argument of the IP literalist. We've already heard from Ken how there can be some very significant differences, but put that to one side. On the other side of the coin, you get privacy literalists. Privacy is the most important thing, and what is private is mine and is not yours. And roughly speaking, you get a division sort of between left and right. Companies that take their intellectual property very seriously perhaps don't take your privacy as seriously. or they're more interested in having your private information and you agreeing through the I agree button to give it to them. So their interests are aligned around holding their intellectual property close to their vest generally, and holding your personal information or having access to your personal information. Likewise, on the other side of the coin, the privacy literalists often tend to be a bit more open source oriented. That's interesting. Is there a common denominator? Because if we can find a common denominator, then maybe these two positions can be reconciled. Suggests that maybe the common denominator in both the case of intellectual property and privacy is a feeling that those ones and zeros, in our case, belong to me. Whether it's the corporate entity protecting its intellectual property, its copyright to the hilt, or it's the individual protecting their privacy to the hilt. Those are my ones and zeros. That's mine. You can't have it. Whether that's tenable or not in this world, as Ken's pointed out, that's the feeling. That's the visceral sense. So we do have a common denominator. And with the common denominator, maybe we can find a common approach. And the approach that we will talk about through the course, and that you will judge, and that we will explore, and it will be distinctly imperfect, is a notion of moral rights. Is a notion that, not that you can't have my property, but you can only deal with it in a way that is consistent with my intentions. And could a regime like that, in theory, not the way moral rights are constituted legally right now, create some sort of salve on the wounds of the area? Now, sorry. The second conundrum around the freedoms versus restraints, or the restraints on freedom issue, is the idea-expression dichotomy. And this is a legal concept, right? Ideas are free. They are not protected by intellectual property law. It is, once they get to the point of fixation, once they are expressed, that legal consequences flow. There is no legal property in principle in an idea. Now we can find mechanisms and ways of concocting something that may look that way in particular circumstances, but as a very general principle, and a very important principle, there's no property in an idea. So just 2 steps back. There's an enormous amount of criticism of the legal system, of us as lawyers, and implicitly of you as law students, that the law is not kept up with the digital times, and that we're falling behind, and that the law is inadequate, and that what is going on around remixing and mods and sharing and machinima proves all of that beyond a shadow of a doubt. That was interesting in one of the year-end sort of wrap-ups of 10 predictions for 2013 from one of the digital media mags. One of the predictions was and the law will fall further behind in 2013. Cheap shot, easy shot, to be expected. Question I want to hone in on quickly. Is this a legal problem? Is it really a problem with the law? And it may surprise you that I'm going to argue this isn't a problem with the law. That the law is correct. That the idea-expression dichotomy works in certain circumstances. So I'll just invite you. We're in a classroom. There's a picture of a classroom, literally 70 years ago. Just for a moment, look around. They got notepads. You've got computers. Pretty big difference. They're not publishing their notes to the web immediately. There are intellectual property aspects to their notes. And there's actually some cases on, do college students' notes constitute intellectual property? Are they yours? Is that your intellectual property? Is it my intellectual property? I'm the one talking about it, but I'm just expressing a bunch of ideas, quite clearly. Some bad ideas. You can look up those cases. They're very relevant to what Ken was referring to. This is a drawing I found on net of how a MOOC works. And we're actually doing a MOOC, right? We're filming this. We've got a blog site up. Some of us are twittering about the course. Twitter feeds are on the blog site. We have a whole bunch of stuff going on. That means that everything here has intellectual property consequences at this very moment. We have actually one of the housekeeping items was we now have a Creative Commons license on the blog site. And there are various flavors of Creative Commons license. And I wanted you guys to comment to me as to whether you feel we've taken the right flavor or not. It's also a good exercise. It's easy to find that. So, and then there's obviously the ad for please post at the blog. It's a big deal. What am I on about? Take the two things we're talking about. The literalist dichotomy is essentially private versus public, right? Privacy rights versus what's in the public domain, whether it be copyright or information about an individual. The privacy literalists are worked up about information about individuals. The copyright literalists are worked up around the property aspects of intellectual property. But essentially, it turns into a private-public dichotomy. And that lines up pretty well with the legal concept of an idea-expression dichotomy. It's all very nice. And once upon a time, in the picture of the classroom 70 years ago, it looked like this. And everything was nicely in balance. In the digital world, it looks like this. Ideas live as non-intellectual property for a relative nanosecond. They're on somebody's computer. They're tweeted. They're repeated. They're on a blog. They're on video right over there in the corner. As soon as that happens, it's expression. As soon as you got expression, you got intellectual property. Likewise, in the digital world, Facebook, Google+, games, communities, blogs, whether it's to the same degree or not, but the territory of the private has gone much smaller, and the territory of the public. This isn't a bad thing. There's no judgments here. This is just what's happened. And it's presumably happened because we wanted it to happen. And so I'm not at all being judgmental. You will find lots of ministers and rabbis and others being judgmental about it. But that's not, I don't think it's a bad thing. In fact, I think it's a good thing. But there's been change. Please. All right, we won't go there. Huh. I am really messing up here. There has been change. Ideas become small, private has become small, expressions become big, public has become bigger. So I argue it's not a failure of law, it's a failure of balance. And balance can be addressed within the law. This isn't about a failure of law. This is about an evolution of law. That's where the right to create might come in. And what does it mean? The right to mod, the right to use, the right to share, the right to remix, perhaps all of those things as rights of individuals. It's one idea. There are many ideas out there, probably many better ideas out there. Supreme Court of Canada has given us a bit of a head start, perhaps, in the pentology. There's a notion of user rights. Whether that notion of user rights is simply in response as a defense to intellectual property action or as a separate right, something we will explore more and is something that ties into the opening question for this class. Also, do not underestimate the BC case of Crooks versus Newton and the Supreme Court finding in that case of a right to hyperlink. Pretty important. So this becomes about evolving a single standard. And to go to what was raised right off the top in this class by a number of you, we are all in this together. Users are creators, creators are users. Those lines are jumbling. That's actually, I would argue, that really is a good thing. And what I'm showing you, and each of you for your own gaming community would have a similar story, I'm betting. On the left-hand side is 1997 original version of Grand Prix Legends. At the time, the greatest sim of its time, and what really got me into serious PC gaming. On the right-hand side, the model of the Honda Formula One car built on the original by the community a couple of years later, either with permission or tacit permission. It was never completely clear. And I remember the group that made that was called GPLEA, and you would wait months to get one of their new cars, and they were so perfectly rendered. This would have been 2000. And they were such works of art that, in the words of my daughter, it would just make you joyful when it was finally released. So these were the creators. These were the users. It's interesting. It goes to the point of who's who. And does it matter so much anymore And if it does matter, how does it matter? And the rest of this course really ends up being about that. So one more wild and crazy thing. And this is kind of wild and crazy and a little bit out there. So Kevin Smith, who's a lawyer and the librarian, the law librarian, I believe, but maybe just the general librarian at Duke, published, Duke University, published an interesting blog take. And remember, this talk will be up on our blog tonight, so you can click through to all of these links, which correlates strong economies and weak IP laws. Remember, just as we will deal with when we talk about violence in video games, correlation is not causation. Correlation is correlation. But takes data from different sources and with all the appropriate warnings that this is just correlation, wonders in a responsible way whether weak IP laws make for strong economies. Now, I find that interesting, maybe important, disturbing, and I'm just not happy with it. So I did my own correlation, my own version. And I wanted to add one more element. And I want to see, and this is pure gut and Google. There is not science here. This is, I had a feeling, and I went to look for it. And I wanted to introduce into this element, because obviously what's a little unsatisfying about Kevin Smith's piece is, yeah, strong economies, weak IP laws. Where's the rule of law? Where's justice? Where's other stuff that we find really important? So I wanted to add that in. And there's a wonderful piece called the Rule of Law Index, easy to find. And just Google it. I just didn't have room to put in the sources here. But they're all easy to find because I found them. The highest rankings in fundamental rights and open government were Norwegian countries. Found a piece from the World Economic Forum, the world's best economies in 2012. And literally, this is how I looked at it. This was not me picking and choosing data to find what I wanted to find. Global competitiveness, Finland was 3rd, Sweden was 4th, the Netherlands was 5th. Ranking pretty high. Roughly, I think it was 140 countries. And found something, this is probably the least certain piece of this, but it's done by a U of T professor, so he must be good, he's Canadian, called the Global Creativity Index. Sweden 1st, Finland 3rd, Denmark 4th. Perhaps a suggestion that rule of law mated with creative tolerance does yield economic advantage. Now, this needs a whole lot more work and would make a wonderful paper if somebody wanted to really look at Norwegian intellectual property law and whether things like right to use, right to remix, exist or how they are treated by the courts in Sweden, in Norway, in the Netherlands, etc. So that's last thing to think about. And next week we get having gotten you hopefully thinking about what your perspective is, and to a place where you can choose your own, we'll delve into specifically remixing in games. And that will involve us deeply in what is the property in a game, and how did the statute of Anne get to be the statute of Anne? Because that may give us some hints as to whether property really means property. So I thank you. Why don't we take 2 minutes, and Rock will then take us on a magical mystery tour of the case law, among other things. Thank you very much.